Good evening. This is our second webinar. So I will just give you a brief introduction as to how we have been trying to go ahead with the webinars. We had posted 2 questions. You can see the questions. I'll just share the screen now, so you'll be able to see the questions. These were the hold on. Yeah, these were the 2 questions that we shared. So we will discuss the questions first, and we will also look at. Hold on. Okay, we will also look at a new feature that we have introduced. So I will first take you to the new feature, which most of you I feel will find it very useful. Now, if you come to the courses here and click on the courses, you will find that along with the available courses, we have introduced revision tests. And those of whom who have taken this will know that this revision test will give you a hands-on feel on the topic which we have covered. Now, the first revision test is on patent applicant. I just quickly take you through so that you will know how this works. Now, I hope you are able to see the screen. Now, if you take the revision test, if you click on this button, I hope you can see the. Okay. Please hold on. There's some issue here. Okay, so the revision test starts off with the first topic that we have is patent applicant. Now, how we have designed this test is we have looked at section 6, which largely talks about patent applicants, and we also looked at all the corresponding provisions to the extent that we could, which covered a patent applicant. So we came up with this test which covers different parts of the act and the rules. So the first question, initially yesterday when we had posted it, there were some errors. Now those errors have now been taken care of. So some of you had some apprehensions on some choices. I hope all of them have been addressed now. So I'm just going to randomly pick some of the questions and answer them here. So country 8 does not allow true and first inventors from India to file patent application in the country. A national of country A who is a true and first inventor of a novel invention wishes to file an application in India. Which of the options are correct? Now, he cannot file the application in India, file a patent in that country only through a legal representative, file a PCT application, none of the above. Now, the correct answer is he cannot file because this is based on a provision in the Patents Act which deals with reciprocity. Now, those of whom who know the provision can put that in the chat box. What is the provision that is covered here? Okay, I'm not going to look at the answer now. Somebody has to sit here. No, somebody has to sit here. I need to have eye contact. I hope you can see the screen now. Yeah. So the first question, which I just read, you can choose, if you choose the first answer, and I'm just going to answer all of them randomly. So I choose next. I've read the question, so I'm just going to go ahead with this. So we can have the discussion. I'm just going to randomly choose the first one just to show you how this operates. And I'm just going to choose some choice so that we can have the discussion with all the questions in front of us. Okay, that brings me to the end of the quiz. Now I can finish the quiz and it will generate the results, and I can restart the quiz if I want to do it, or I can view the questions. Now here I can see that I've reached 5 out of 11. So I got 5 of them wrong out of 11. So when I view the questions, it shows me how I fared. Okay. Now A is the answer for the first one. A is the answer for the second one as well. The third one is I've chosen the correct answer. The fourth one though, I chose only one answer, and I did that deliberately so that you know that. So it will still show that in green. What it will do is it will show that you have not ticked B and C, which also ought to be the correct answer. So in effect, it shows that your answer is incorrect because you didn't tick all the correct answers. Now the way we have designed this, we have kept it as a multiple answer type question. Though the Patent Office conducts the examination with only one part of the question paper having multiple answers being correct, we have all our questions will have multiple answers correct, which could also mean one or multiple. So we have kept it that way so that you get trained on the harder part, and you will also get to see how you fare. So you need to really know the answer correctly to get it right. True and first inventor can. I got only one right. I didn't click the other two, so it shows as incorrect. Then assignee, again, I got them right. What happens when a patentee dies? Again, I got one wrong. I should have got another one right. And patent applicant will disclose in form A. I should have ticked address of the applicant as well. And form 1, again, there is I had not ticked 3 other answers. So this is only to give you a heads up on how the quiz actually operates. Now, ideally, if you have any questions on the quiz, you should use the forum. And we have been seeing that there is some traction on the forum. People have been asking questions and we have been answering that. So you could raise a recent topic saying revision test 1 and whatever question it is, so that it gets the benefit is shared with a larger audience. So whatever you want to ask, for instance, you need to ask a question on this. You'll go to the forum, look at the recent topics. You can come to the forums, and ideally you can choose under which course you need to answer, raise the question, and you can raise the question and we'll try to answer that. So now let's move to the question that we had to look at for today. So this is the question. Question number 1. I hope you would have read it. This is largely based on the facts of the Novartis case, and there is a clear giveaway in the way in which we have phrased it. But this is the Novartis case with a small twist. So I'll just read the question again. Clovaris, a multinational pharmaceutical corporation, developed a compound imatinib as a cure for chronic myeloid leukemia. The corporation filed a patent application for this compound on 15 January 2011 and was granted a patent in India on 15th July. However, this compound was not ready for clinical trials on human beings. Several iterations and modifications later, the beta-crystalline form of imatinib mesylate was finally identified as a perfect candidate for clinical trials to tackle CML. The beta-crystalline form of imatinib was a polymorph of the earlier identified imatinib, however, with a 30% increase in bioavailability and better shelf life. Clovaris named the new compound, the newly identified compound, Zlenac. Now, Clovaris has approached you to file a fresh patent application in the Indian Patent Office. advise Cloaris advise them on the following aspects. 1. Whether the new identified compound Zlinac can be patented as per the Patents Act. 2. How can efficacy be established in the case of a drug? 3. Whether increased bioavailability and better shelf life will be considered as increase in efficacy. And what is the best way to protect the beta crystalline polymorph of imatinib mesylate? Now there is a link that we will be sharing like last time, the Google Doc. We have shared the Google Doc, so you should raise the questions whatever you have in the Google Doc, and we will try to answer them on the Google Doc. Now, so the question is quite simple. It is modeled on the Novartis case, and the questions are whether the newly identified compound can be patented as per the Patents Act. Now, people who have knowledge of the Novartis case are going to say no, it cannot be patented because the patent was rejected, and the rejection was upheld by the IPAB and finally by the Supreme Court. Now, how do you establish efficacy of a known drug? Now, to answer this question, first you need to know about Section 3. Now, Section 3 deals with exceptions to patentability, what are not inventions, and Section 3 has a long list of exceptions. The relevant section for this is Section 3D. And when it comes to Section 3D, you will know that Section 3D has 3 parts. Section 3D has 3 parts. The first part pertains to new forms of known substances. The second part pertains to new uses and new properties of known substances. And the third part pertains to new property. Third part pertains to new process. Use of a known process which involves which results in a new product or employs a new reactant. Now, the provision that will apply for this question is the first part of Section 3D. So you understand that the only relevant part of Section 3D that applies for this case is the mere discovery of a new form of a known substance which does not result in the enhancement of a known efficacy. So you have to mention the section, you have to say how that section is relevant, and you have to show that this is the relevant provision that will be applicable. And because it's a new form of a known substance, it's a polymorph, and polymorph was defined in the explanation. So that will be the first part. You can say that by the understanding of Section 3D, the first part of Section 3D, a polymorph which is covered in the explanation. The explanation reads, for the purposes of this clause, salts, esters, ethers, polymorphs, metabolites, etc. shall not be considered as the same substance unless they significantly differ in properties with regard to efficacy. So you'll have to give the explanation, you'll have to say this provision which bars patenting, that is 3D, you have to give the explanation, and you may also refer to the Supreme Court case. If a case comes around Novartis or around the application of Section 3D, you can always mention the Novartis AG versus Union of India, which is the Supreme Court decision that came in 2013. Now, how can efficacy be established in the case of a drug? Now, for this, you will have to go back to the Novartis case. The Novartis case, the Supreme Court had given a list of things that have to be shown in the case of proving efficacy. Now, I'll just pull up a PPT. These principles were listed. The following principles were listed by the Supreme Court. The first one was identifying the new form of known substance and its pharmacological properties such as efficacy. Now, I've given the paragraph numbers here, so you will be able to see the paragraph numbers from the Supreme Court decision. So hold on. Okay, so you can see the paragraph numbers from the Supreme Court decision. The first thing is to identify the new form of the known substance and its pharmacological properties such as efficacy. The second one, these are not steps in sequence, these are rather principles that the Supreme Court evolved. The second one is to compare the pharmacological properties of the known substance with the new form of the known substance. So the Supreme Court says, once you identify the new form of the known substance, you have to compare. Now, what are you going to compare? You're going to compare the pharmacological properties of the known substance with the new form of the known substance. Now, that's para 163. The third thing that the Supreme Court says is that to provide a comparative material on enhanced efficacy in the patent application or by affidavits. Now, you have to provide comparative material on enhanced efficacy, which is merely making a statement that the new form exhibits enhanced efficacy is not sufficient. You have to provide comparative material. Comparative material could be by tests. There are some decisions which says that there has to be some form of a clinical data. They don't say clinical trial. Some form of data to show that the new form has an enhanced efficacy. So that has to be either in the patent application itself or by way of affidavits, because most of the time you would have filed your patent and an objection is raised, say, through an FER. So the law allows you to file evidence in the form of affidavit. Now, there is a provision by which evidence can be adduced in before the patent office. I'll just quickly take you through the provision so that you know how evidence can be let in. If you come to Rule 126, Rule 126 tells you how affidavits can be filed. So when in paragraph 171, where the Supreme Court says that you can let in evidence by affidavits, it is referring to the form by which affidavits can be let in. So Rule 126 deals with that. And the fourth point is that excluding physico-chemical properties like more beneficial flow properties, better thermodynamic stability, and lower hygroscopicity for considering therapeutic efficacy. Now, this was another principle that the Supreme Court developed, that in determining therapeutic efficacy, you will remove or you will eliminate properties like beneficial flow, thermodynamic stability, or hygroscopicity. So you are actually looking at only the properties that contributed to the therapeutic efficacy. The fifth principle involves, in the case of medicines, the test of efficacy can only be therapeutic efficacy, which should be judged strictly and narrowly. Now, we know that even before the Supreme Court came up with this interpretation that efficacy in the case of drugs, medicines have to be therapeutic efficacy, we know that the Madras High Court has already held equating efficacy to therapeutic efficacy. This was the first round of litigation that Novartis had in the Madras High Court, where this interpretation was given by a division bench. Now, Supreme Court adopts this interpretation and says in para 180 that if it is a drug, then we will understand efficacy as therapeutic efficacy. That's the fifth principle. The sixth principle is about that the applicant has to specifically claim and establish by research data correlating bioavailability to enhanced therapeutic efficacy. Now, the court does not say that we will dismiss bioavailability. It says that bioavailability could be something that can be factored for considering enhanced efficacy, but there has to be a correlation of research data on bioavailability to show enhanced therapeutic efficacy. Now, that was in para 189 of the Supreme Court's decision. The seventh principle, the court says that for patents involving new forms of known substances in chemicals and pharmaceuticals, the test of enhanced efficacy should be proved in addition to the fact that the patent application is an invention and involves an inventive step, which simply means apart from demonstrating patentability, which is section 2(1)(j) requires every invention to be novel, to involve an inventive step, and to have utility. Apart from showing patentability, 3D will be considered as a separate step. So 3D the court said and interpreted it as not being a part of the patentability test. Rather, 3D falls under the category of exceptions. So you look at the exceptions, you look at the patentability criteria as well. So it is not one for the other, it is one and the other. So this is what the court came up with in 7 principles. Now these 7 principles were not effectively applied in cases that came after that by the patent office. But if you need to say how therapeutic efficacy can be demonstrated in the light of the Novartis case, please note the paragraphs. These are the paragraphs that you will be quoting, or this is the gist that you will be saying if you have to show, because there is nothing in the patent guidelines for pharmaceuticals which is as clear as what you now see on your screen. Now let's get back to the problem. Okay, now that answers the second part of the question. How can efficacy be established in the case of a drug? And we also kind of covered the bioavailability issue, whether increased bioavailability and better shelf life can be considered as increase in efficacy. The court clearly says that if you have to consider bioavailability as increased efficacy, there has to be research data correlating it. And better shelf life, the court excludes better shelf life. Stability, thermodynamic stability is excluded by the court. So you'll have to give your answer accordingly. So this may go beyond the act, but this we have seen in 2016 there was a question on the Novartis case. So that's why a reading of the Novartis case, at least the important paragraphs, will be beneficial. Now the last question is, what is the best way to protect beta-crystalline polymorph of imatinib mesylate? Now if you see, we had slightly tweaked the facts in this case. Now in this case, it is possible, if you want to give an answer, it is possible to file a patent of addition. In the real Novartis case, it was not possible because the first application Novartis filed was for the beta-crystalline version. In the facts in which we have demonstrated, there is already a pending application which got granted in 2018. 15th July 2018 it was granted. So because there is a pending application, we can treat that as the main invention under section 54, which allows for patent of addition, and you can follow it up with a patent of addition. A patent of addition, we again 3D will stare at it, but you can, if you have to try a chance to get a patent, then all you can, or the best you can do is to say that these are improvements over the existing drug, and these improvements have been disclosed by the has been disclosed in the complete specification. The compound has been disclosed, but the improvement is filed as a patent of addition. So that is the that concludes the first question. Now let me quickly take you through the second question as well, and then we'll open the floor for the questions from your end. You able to hear now? Okay. Where's the Google Doc? There's the chat box. I can click on the list. Now question 2 pertains to an inventor. Ronnie Shark invented a powered exoskeleton, an armored battle suit with a unique nanotech generation system. Ronnie assigned his invention by way of an agreement to Shark Corporation, a multinational corporation which later filed a complete specification in the United States on 15th Feb 2016 with a priority date going back to 15th January 2016. After 6 months from the date of application, on 15th July 2016, Shark Corporation filed a PCT international application designating United States as the International Search Authority. After 12 months from the date of filing the PCT application, on 15th July 2017, Shark Corporation filed a national phase application in India for the same invention. You are appointed as the authorized patent agent for Shah Corporation to prosecute patent applications in India. On the basis of the above facts, answer the following questions. Now that you have been appointed as an authorized patent agent for the applicant, the same has to be intimated to the patent office. How will you do that? It's a pretty straightforward question. How will you intimate the patent office? The client has got in touch with you. How will you do that? Okay, so you should know how a form of authorization is filed and what is the form used for filing the authorization. Within what period should such intimation be made? The time period within such intimation should be made. What happens if you fail to intimate the patent office about such appointment after filing the application? Now there is some layer to this. The third question, you have to see there is a information that you may miss out on the third question. 4. What will be regarded as the date of the patent as per the Patents Act? Now there is a provision which talks about the date of the patent. If the patent for the above mentioned invention is granted, when will the term of the above mentioned Indian application expire? Once the term of the patent is expired, can it be extended to a further period? 6. Shah Corporation failed to furnish the proof of right to make an application. Within what time should the applicant produce the proof to the patent office? Shah Corporation wishes to file an expedited examination of application. Advise them. That should be the 7th question. It was not marked here. Now let's look at the questions one by one. Now, you have to look at appointment under Rule 135, which says Form 26 shall be filed within a period of 3 months. Okay. Now, so you will file a Form 26 intimating the patent office, and that has to be made within a period of 3 months. Now, what happens if you file an application and you don't file Form 26? What is the consequence of filing an application without Form 26? You can use the chat box. I'm just expecting you to give me an answer, because the reason why we frame this question, there is a particular principle behind it. What happens if you file an application but you don't file Form 26 along with it? You can type your answers on the in the chat box. Okay, we have an answer saying that if you don't file Form 26 without application, you file the application but not Form 26, you may stand rejected. Your application may stand rejected. That doesn't seem to be the answer. Let us see another. Application can be returned under the powers of the controller. That's not the answer either. The third one is the correct answer. No action will be taken by the controller. So the consequence of not filing Form 26 is that the controller will not take any action till that defect is remedied. Till that defect is remedied, the controller is not going to take any action. Now this is why we ask this question. It's not that your application will be rejected or it will be returned back to you. The consequence is there won't be any action in your application. Okay. Now let's look at the next question. What will be regarded as the date of the patent? Now, date of the patent, if you see section 45 deals with the date of the patent. Now, the date of the patent is the date on which the application for patent was filed. So we know the date of the patent as the date on which the application for patent was filed. And if you look at section 53, which deals with term, 53(1) explanation says that for the purpose of this subsection, the term of the patent in case of an international application filed under PCT designating India shall be 20 years from the international filing date accorded under the Patent Cooperation Treaty. So that is the term of the patent. So the term of the patent will be 20 years from the international filing date accorded under the Patent Cooperation Treaty. The Patent Cooperation Treaty assigns an international filing date, and the term in India will be 20 years from that date. Now, if the patent of the above mentioned invention is granted, when will the term expire? And once the term is expired, can it be extended? No, the term cannot be extended. In India, we don't have supplementary term. We don't have a term extension provision under the Indian Act. 6. Shark Corporation has failed to furnish proof of right. Now, what happens if proof of right is not produced? When proof of right is not produced, you have an option to furnish the proof of right within 6 months after filing such application. You can produce the proof of right. Now, this is under Rule 10 read with Section 7(2). And Shark Corporation wishes to file an expedited examination of an application. Now, can anybody answer that? What happens? Can Shark Corporation file an expedited examination? Proof of right, you'll have to see Section 7(2) and Rule 10. Proof of right is to show that you have a proof to file the application. For instance, most of the time it's an assignment deed. If you are the true first inventor, you don't need a proof of right. If you are an assignee, you need the assignment. So, signed by the inventors, saying that the assignment has taken place, and the assignment deed becomes the proof of right. Okay. Now, can somebody say this? The 7th question, which is Shark Corporation wishes to file an expedited examination of the application. What can they do? Can Shark Corporation file an expedited examination of the application? Yes, that's partly correct. Expedited examination is for startups. There is an answer saying that yes, Shark chooses India as ISA, but that's already done, right? We saw in the question that they've already chosen US. So they filed the international phase designating US as the international search authority. So US is already chosen at ISA. So once you choose US as ISA, you cannot now choose India as ISA. So the option to file an expedited examination is open for applicants who choose India as the ISA or the preliminary examination authority, or it is open for startups. Now we know that Shark Corporation does not fall within the definition of a startup. It is an existing corporation, and though we have not talked about the turnover, the assumption is that it's an American corporation, so multinational corporation. You can easily remove all multinational corporations from the purview of a startup, because the startup definition does not allow multinational corporations to be to qualify for the startup status. So in both the scenarios, it doesn't fall. So you have to tell them that an expedited examination is not possible for this application. Okay, now let me just go to the document and Okay, you can, if there are any questions, you can just start posting them here. Okay, 53 talks about the term of the application. The term of the application begins with, it's a 20-year term, and the term in all cases is calculated from the, hold on, let me take 53. The term in all cases is calculated from the date of filing the application for the patent. Now the application is understood as the application filed disclosing the invention. Okay, people are still typing the question. I can direct you to a question that was asked in the forum sometime back, and I think it is here. And one good thing about the forum is that you can search the forum for topics. There was a question, I think, on priority date. Yeah. So this is a much more detailed answer, and there was a particular question asked about the 20-year term. When does the 20-year term begin for an international application? Okay, so there is a detailed answer there, so you can come to the forum and see that. And the idea of a forum is that you can see one of the participants raised a question. We were able to answer it. There were follow-up questions, and we were able to answer it as well. So the forum, if you ask me, if the forum is the best place to raise your questions so that we can answer it till you get clarity on the issue. And again, there is no point in answering the questions again whenever it occurs to a person. Rather, the forum becomes a place of record. If you have answered something, and if you have not understood something, you should ideally ask a question under this thread. It's open for you to ask a question under this thread. So there is a detailed account on when the 20-year term. The difference between, one thing you need to consider is that foreign priority is not considered in determining the term of a patent. Okay, this is a foundational principle you should bear in mind. Many a times you get confused by a priority document filed in a foreign country. It is not considered. The term starts with the filing of the complete specification, the term on which the complete got in. When the disclosure was completed, from then on the term starts. So the 20-year term, another way to understand this is, you can go to a granted patent on the Patent Office website and see the renewal page. There is a page where the fee is renewed every year. So you can see that the Patent Office demands the fee after the grant, and it will ask you to pay the fee for the time the patent was under prosecution. So if you get a patent granted on the 4th year, when the patent is granted, the Patent Office will ask you to pay the fee, backdating the fees, because when it was in the when the application was pending prosecution, the Patent Office did not take fee from you. So there is always an element of going back in time and paying the fees, and you can see that from the date of application they start demanding the fee, which means from the date of complete filing the complete. Yeah? From the end of the second year. So you can see the pattern by which renewals happen, from the end of the second year they demand the free. So you pay for the first 2 years. You pay for the your initial fee covers the first two correction. The first 2 years is free, so you end up paying from the end of the second year. Okay, the 3 parts of section 3D, I mean, I'll just take the questions again. We have mentioned that in the video on section 3. There is an explanation of the 3 parts of section 3D. 3 parts are, the first part pertains to new form of a known substance. If you have section 3D right in front of you, you can just underline it. The first part pertains to new form of a known substance. The second part pertains to new use or new property of a known substance. And the third part pertains to a known process which involves a new reactant or which results in a new product. So these are the 3 parts. And in Novartis case, only the first part came into question. Okay, repeat. Okay, the term of the patent is determined from the day of filing the complete specification. I told you that priority is not, priority and term are 2 different things. Foreign priority is not considered for determining the term of a local application. In the case of a convention application, we read out the exception in section 53, explanation in section 53. It is from the date of the patent as assigned under the Patent Cooperation Treaty. Okay, there is a provision in which the date, see the date can, the reason they say it that way is if you read the PCT regulations, there is a way, there are measures by which you can change the date of application if your application is incomplete. They are exceptions. Normally it is the day on which you file the basic application. So your date according to PCT starts from the day of filing the basic application for a convention application or filing the PCT for the day you file the PCT or the basic application. The day starts from that. In some cases, you can, if you have not completed the documentation, the PCT regulations say that the date can change. Okay, whether increased bioavailability or better shelf life can be considered efficacy. As per the Supreme Court, increase in bioavailability can be considered for efficacy, provided there is research data that is correlated. Research data pertaining to bioavailability has to be correlated to therapeutic efficacy. Only then it is considered. Better shelf life is not considered at all. So you are out to split your answer into 2 parts and answer it and mention it. No, all the 3 need not be qualified. In fact, 3D, the 3 parts of 3D apply for 3 different cases. The first part deals with new forms of known substances. The second part deals with new uses and new properties, which would come in, say somebody wants to now patent aspirin and say that it's a 100-year-old drug, to say that aspirin can treat stroke. So the new use of aspirin, the use of aspirin for treating stroke has to be patented. Now 3D, the second part will prevent them from doing that because the second part of 3D does not allow new uses to be patented of known substances. Is expedited examination available for registered small entity SME units also in? Yes, if you see the definition of startup, we have a new video on that. If you see the definition of startup, a startup is an entity that is defined as a startup under the startup initiative. Now, under the startup initiative, you can be an entity if you are registered under 3 different enactments. If you are registered under the Companies Act, you can be a startup. If you are registered under the Partnership Act, you can still be a startup. If you are registered under the Limited Liability Partnership LLP Act, you can still be a partnership. So a small entity is not based on registration under a particular act. It is based on your status, how long you have been, how did you begin, where you shelved off from a bigger unit or you started off on your own, and what is your turnover in the last 5 years. Now this again we have explained it. If you are going to claim a patent of addition for a polymorph, assuming that the main invention is granted in your name, there shouldn't be any problem. There shouldn't be any problem. You can file a patent of addition for a polymorph if the main invention covers the substance. The main invention, let me make it clear, the main invention covers the known substance, and you want to follow it up with an application for a patent of addition. You can file a patent of addition because the main invention is already disclosed. So the patent of addition will run along with the main invention. Okay, why Novartis did not have the patent of addition option is because Novartis did not have a main invention filed in India. That is the reason. Had Novartis filed a main invention and then followed up with the application they filed in India, it would have been possible. But Novartis, because the main invention was disclosed in 1992 and the Indian regime did not grant product patents, and that's the reason Novartis didn't enter the Indian market. What about the fee and other process for patent of addition? That you can just check up in the Act and the rules, the fees for a patent of addition. It's there in section 54, 55, 56 and the related fees. You have for why Novartis couldn't prove, multiple reasons. Novartis relied on a test of 30% increase in bioavailability in rats and tried to correlate it. And there are reasons in the judgment you can see why it was not accepted. One of the reasons was there was no research data correlating bioavailability to therapeutic efficacy, which is one of the principles that I read out. See, 3D only talks about new form of a known substance, and it talks about an explanation where it gives you the different forms of a known substance. Now, assume that your polymorph has some kind of an enhanced efficacy. Let us assume for a moment your polymorph demonstrates enhanced efficacy. You should be able to get over 3D objection if your polymorph demonstrates enhanced efficacy. And if it demonstrates enhanced efficacy, the way in which you can claim a patent for it would be through a patent of addition. Okay, I just put the screen on pause. Okay, so we are not able to, we had a poll prepared. We are not able to share that with you. Anyway, we are the next week. I mean, we are just trying different slots. Last time we had it at 10 o'clock on Saturday, and now we have this at 5 p.m. The next week we may try Sunday at 11 p.m. Just let me know whether Sunday, not 11 p.m. Sorry, Sunday 11 a.m. will be convenient slot for you. Because we have a very heterogeneous batch. Many of you are working. There are people who are doing full-time study. In fact, we have seen people make great progress in the videos. Some of you have completed close to 60% of all the lessons, so which is a great thing. But the accommodating heterogeneous audience like this becomes very hard. So some of you may have to sacrifice your Sundays. Two responses. Somebody wants it at Sunday 11 a.m. Somebody wants it at Sunday evening. So you can just see the difficulty, right? And somebody says 11 a.m. is not possible. That's it. I mean, 3 choices I just received. 11 a.m. is best. Sunday evening 11 a.m. is not possible. Okay. Sunday anytime, best anytime. Sunday 5 p.m. is also okay, but you get the point, right? I mean, it's impossible to find a slot which suits everyone. So the best that we can do is we can make the recording available. Okay, so morning session anytime on Sunday is fine. Okay, we'll factor this. We good that you are all typing this up. How about Sunday night 9 p.m. That's the time I normally go to sleep. Okay, but I can give you a counter. How about 5 a.m. on any day? Okay. No, I'm just giving you options. Okay. Recordings will be made available. Yes, recording. So don't worry if somebody cannot make this. The recording will be made available. But bear in mind, it is much more easier for you to. We can have the webinar. I can explain certain things, but follow up to questions should ideally be done on the forum. So that's how we have structured this. The webinar will give you tips like the 100-page no artist case, which you should have read for the exam. I just gave you the gist in one screenshot. 7 things that you need to take from the case I gave you. Now this can happen in a webinar. Answering every minute question of yours is going to take some time. So what I would suggest, I would take the webinar, give you, because webinar is going to be the practice session for the questions that are in paper 2, and we will come up with more hypothetical questions and answer that. Any follow-up on the forum, you can just say that question number 1 in webinar number 2, and you can just follow. We'll start the conversation there so that we get the time to give you a more detailed response. Okay, so this is how we have structured it. We have the courses, and please make a point to look at the revision test, and just to tell you again, the revision test appears in courses. As you can see now, in courses, under the available courses, you will find the revision test. So you can just click on it and start taking it. Okay, so kindly clear the last doubt in the Google document. Don't worry if the times get coming to an end. If anything that remains, please post it on the forum. The forum is open. We will answer it there. If anything remains, please follow it up on the forum. So we'll get back to you. So tomorrow there won't be a seminar. We will get back to you